Are we ready?
Please go ahead, sir. I've started. Good afternoon, investors. We're live. MDB, we're live.
Thank you. Well, good morning, friends and colleagues, and welcome to this Chartered Institute of Arbitrators webinar, Arbitrators Fees, Navigating Through the Issues. Right now, I can see that we have 69 participants, 70 numbers fast changing, logged on. I expect that we'll have more of our colleagues logging on as we go along. One of those already logged on is the chairman of the Chartered Institute of Arbitrators, Mr. Olatunde Busari, SAN. I'm specifically mentioning him not because he's the chairman, as important as that position may be, but because this webinar is at his initiation and upon his direction. So I would like to thank him very much for providing the opportunity for us to discuss this very important subject, which I believe is going to be, very lively and informative. Our topic today raises so many issues. At what stage of an arbitration do you charge fees? How do you assess those fees? What factors do you take into account? Do you apply a scale of fees or not? What happens when one party pays its share and the other party doesn't? What happens when fees have been fully paid and the parties settled? Are part of those fees to be returned to the parties? What happens where the parties do not pay at all or do not fully pay, but the arbitrators have done their work? What are the expectations of the parties in all these situations? So there's so many questions and more. Even though the rules, the law and the rules of arbitral institutions attempt to provide answers to these questions, in reality, when confronted with these situations, what to do is not always easy or straightforward. I will not attempt to provide answers to any of these questions. We have a very rich panel oozing with experience to deal with all of these questions and more. The panelists are all distinguished arbitration practitioners who require no introduction, and I doubt that there's any participant here that has not at least heard of them. I will just nevertheless mention the names, and just for identification, I will introduce them, each panelist briefly as and when they are about to speak. Not in any particular order. We have Chief Bayo Ujo. Chief, please kindly acknowledge, just for those who may not know what you look like.
Good morning,
which
all.
I doubt.
Good morning, everybody.
Thank you. Then we have Mr. Oba, sorry, needless to say, Chief Bayo Ujo is a senior advocate of Nigeria. I will save the other introductions later. Mr. Oba Nsugbe, QC, SAN.
Morning, everybody.
Thank you. Mrs. Funke Adekoya, SAN.
Good morning, good afternoon, good evening, depending on where you are.
Thank you. Dr. Isaiah, Mr. Isaiah Bozimo, I think he's gone off for the moment. Okay.
I'm still here.
I'll come back to him. Okay.
Thank you.
Mr. Isaiah Bozimo.
Good morning, everybody. Delighted to be here. Thank you for joining.
Thank you. And last but not the least, Dr. Wale Olawoyin.
Good morning, everybody.
Okay, thank you. So the format is going to be this. Each speaker will have 10 minutes. If you have any questions or comments, please post them to the chat, and at the appropriate stage, we'll get our panelists to answer them. After all panelists have spoken, we'll have a roundtable discussion to discuss issues that have arisen from the presentations made, from your questions and comments, and issues raised by me to the panelists. I will encourage you to send in as much comments and questions as possible. It is your participation that will primarily determine the success of this webinar. There may not be enough time to get through all the questions and comments, but we'll try to take as many as we can. That is why we're setting a lot of time out for the interactive session. Also, in the course of this webinar, we shall be conducting a few polls. And again, I encourage you to fully participate in that. So without much ado, we will start. I'll call on Mrs. Funke Adekoya, a senior advocate of Nigeria, a founding partner of the law firm Alex. Mrs. Adekoya has so many parts in arbitration. She's known locally and internationally. And if I were to begin to go through her profile, I think we'll probably eat up all the time of the webinar. Like I said, she needs no introduction. So I'll just call on Mrs. Funke Adekoya to set the stage for us. Mrs. Adekoya, over to you.
Thank you very much, and hello, everyone. My job really is to set the stage for the discussions by basically giving you what the legal framework is within Nigeria, against which we would have this morning's discussions. There is a federal statute, the Arbitration and Conciliation Act. And in Lagos, which is the commercial capital of Nigeria, there is the Lagos State Arbitration Law. Let's start with the federal statute. What does it say about arbitration fees? And it's clear. Section 49(1) says the tribunal shall fix costs of arbitration in its award. And the term cost includes the fees of the arbitral tribunal, to be stated separately as to each arbitrator and to be fixed by the tribunal itself. And then Article 38 in the schedule, which are the arbitration rules, has exactly the same wording. The point to note firstly is that Section 49 of the Arbitration and Conciliation Act is part of the section that applies to international arbitration. So that it would seem as if the domestic part of the statute has nothing about arbitrators' fees. But because the schedule applies to all domestic arbitration mandatorily, where the Arbitration and Conciliation Act applies, which would be firstly, domestic arbitration in Nigeria, and secondly, ad hoc arbitration where Nigeria is the seat. Then for domestic arbitration, we go to the rules in the schedule, and that's Article 38. And Article 39 then says, the fees of the tribunal shall be reasonable in amount taking into account the amount in dispute, the complexity of the subject matter, the time spent by the arbitrators, and any other relevant circumstances of the case. So in ad hoc arbitration proceedings, the arbitral tribunal, whether it's the sole arbitrator or it's a panel of 3, have 4 things to take into consideration. One is the amount in dispute. What's the value of the claim and a counterclaim, if any? Secondly, what's the complexity? How complex is the subject matter? Because that goes to the value of the dispute to the parties. And thirdly, the time spent by the arbitrators. That goes as to the value of the arbitrator's time. How expensive is the arbitrator? And any other relevant circumstances. Now, what would one consider is a relevant circumstance? Now, if I, as an arbitrator, am appointed in a dispute that would then result in a situation where I would have to declare a potential conflict in other similar circumstances, then obviously that is a relevant circumstance that I would take into consideration. That by taking on this matter, I am potentially losing the opportunity of income in other similar matters, either from those parties or from those issues. So invariably, what the rules, the arbitration rules in Nigeria say in terms of ad hoc arbitrations are that arbitrators' fees are valued on the ad valorem basis. And I think the regular English dictionaries define ad valorem as something that is in proportion to the estimated value of the goods or the transaction. We know that estate agents charge between 5%, 7.5% to 10% as their fees based on the value of the property being sold or the property being leased, as the case may be. We know that standard terms for debt collection range from 10% to 30% of the debt that is collected, depending on whether it's a full contingency or there's some guaranteed level of income. The first thing to note is that there's no guarantee under the Arbitration and Conciliation Act that the fees will be paid at all. And that's one of the things that will be discussed in this segment. There's also no enforcement mechanism in the Arbitration and Conciliation Act, even where the arbitrators and the parties have agreed fees, and then one party then refuses to pay. What the rules say is that when one party doesn't pay, the arbitrator shall call upon the other party to make that payment. What happens if the other party then says, I'm not making that payment? What happens? So those are another issue that we need to consider. Now let's look at where the Lagos State arbitration law is different. But starting with where it is the same. Section 51(2) of the Lagos State arbitration law has exactly the same wording as Article 39 of the Arbitration and Conciliation Act. So the basis for determining the arbitration fees are the same. It's an ad valorem basis, identifying the 4 issues that are concerned. But the difference is the Lagos State arbitration law provides some protection in terms of arbitrators' fees. The section 12(5) of the law says that where the court removes an arbitrator, it may make such order as to fees as it thinks fit with respect to the entitlement of fees and expenses, or an indemnity for legal expenses, or a refund of fees or expenses already paid. In the absence of any agreement, the arbitration law of Lagos State also provides in section 14(2)(2)(a) that where an arbitrator resigns his appointment, the arbitrator may apply to the court to make an order as the court thinks fit with respect to the arbitrator's entitlement as to fees or expenses, or the repayment by the arbitrator of any fees or expenses that have already been paid. So there's guidance in the arbitration law as to what should happen. Section 49(2) of the Lagos State law also says that the arbitral tribunal may refuse to deliver an award to the parties except upon full payment of the agreed fees and expenses of the arbitrator. So in essence, the Lagos State arbitration law grants parties a lien on the award for their fees. It also allows the arbitrator to go to court where there's no agreement as to the fees. And the arbitrator has stated his fees, the parties have not agreed. Then either the arbitrators or the party can apply to the court, and the court may order that the arbitrator shall deliver the award on the payment into court by the party of the fees and expenses demanded, or such lesser amount as the court may specify. And in specifying an amount, the arbitration law of Lagos State says that the court shall take into consideration the issues. In fact, it says the court shall be bound by section 51(2) of the arbitration law, which essentially means that the court shall look at those four aspects and value the arbitrator's fees on an ad valorem basis. Now, that is the framework that exists. I'd like to end my presentation by saying, in light of the specificity that is stated in the Lagos State Arbitration Law, why are we still writing the Arbitration and Conciliation Act into our contracts? There's definitely more guidance in the Lagos State Arbitration Law. With that, I hand over back to the moderator.
Thank you very much, Mrs. Adekoya. Okay, we'll just go straight to the next speaker, Dr. Wale Olawe. I don't want to steal his thunder by introducing what he's going to be talking about. I think I'll just let him do that straight away himself. Dr. Wale Olawe, SAN, please.
Thank you very much, Mr. Belgore, and good morning to everybody again. Just picking up from Mrs. Adekoya's sort of introductory overview, my remit simply is to talk about effective management of arbitration costs under the London Maritime Arbitration Association, which everybody knows is one of the leading, if not the leading, maritime arbitration institution. And then additionally, I'll talk about current initiatives by the Chartered Institute of Arbitrators Nigeria branch in terms of reviewing the scale of fees in respect of arbitration. So as I said, I mean, everybody knows LMAA. It's an institution that was established well over 300 years ago. And historically, maritime arbitration involved very complex and expensive disputes. But there was a realization that the issue of arbitration costs had to be addressed to sort of enhance the continued patronage of arbitration under the LMAA rules. And my presentation is essentially high level because of the time constraints that I have. And when you look at the structure of the costs under the LMAA rules, they essentially classify the arbitration references into three broad categories. You have the small claims, you have the intermediate claims, and then you have other claims, and I would explain what other claims are. And what you would see in the rules in terms of a guiding philosophy on the issue of cost is that it essentially rests on the twin pillar of fixing costs and also capping, or rather fixing fees and capping costs. So in respect of arbitrators' fees, for example, you will see across the board that arbitrators' fees are largely fixed. The fee of the arbitral institution itself too is largely fixed, and then the issue of legal costs as much as possible. And for each category of claims that I've talked about, you have different rules, even though you have the overarching LMAA terms of 2017. But in respect of the small claims, you have the small claims procedure rules and also the intermediate claims procedure rules. So if we just quickly look at the different claims, for a small claim, it is essentially defined, as it were, as a claim that is less than $100,000, including the counterclaim as well. And if you have that kind of claim for $100,000, the arbitrator's fees are fixed by the committee of the LMAA at £4,000, and then an administrative fee of £350 that goes to the institution. That is also within the $100,000 threshold. There is then an additional arbitrator's fees of £2,500. I mean, you can do some quick calculation in terms of conversion to Naira just to get a context of these figures in a Nigerian context. Interestingly, as regards legal costs, like I said, legal costs are generally capped, but the general principle for the award of legal costs remains that the arbitrator has the power to assess the award of costs summarily and on a commercial basis, but with the important consideration that a maximum figure is fixed at £5,000. And where there is a counterclaim, the maximum cap is £6,000. So obviously it is not that the arbitrator has to award costs in the sum of £5,000, but that is the maximum amount that the arbitrator can award. What you would also see in the LMAA rules are other issues that have either a direct or indirect effect on the effective management of costs. So for example, in the small claims procedure, you don't have any oral hearings except there are exceptional circumstances that the arbitrator approves. And for example, again, the right of appeal is expressly excluded. So that is the small claim. So you can see the structures that they've put in place for the small claims to ensure that costs generally of arbitration are reduced to the barest minimum. In the case of the intermediate claims, these are claims and counterclaims between $100,000 and $400,000. And what you would see is that the arbitrator's fees are also the first level, which is, and then you have the fixed amount, which is assessed at 1/3 of 30% of the claimant's monetary claims as advanced in the reference. And if the tribunal is a 3-man tribunal, then the fixed cost of the arbitrators is actually 2/3 of the amounts. Oral hearings are intended, then the arbitrator's fees may be increased from the 30% threshold of the claimant's monetary claims, or the basis of the calculation rather, will be increased from the 30% to 50%, as the case may be. And then additionally, there's also the standard administrative fee, which is a flat fee of £350 to the LMAA. Just like the small claims as well, with regard to the intermediate claims, there's also no automatic right to an oral hearing, unless there are exceptional circumstances that demand such. Again, recovery of cost is also capped. And in this case, it's the same formula of the 30% of the monetary claim, which is the maximum amount of costs that are recoverable. And then there are additional initiatives like no expert witness may be adduced. And then in the particular context of the intermediate claims, the right of appeal. And when I talk about the right of appeal, because this is essentially on the basis of English law, unlike our own situation. So you don't start wondering what is the right of appeal. The right of appeal too is qualified in the sense that it is limited to only situations where it is alleged that the award gives rise to an issue of either general interest or of extreme importance to the maritime trade or industry in question. And even that point requires the certification by the tribunal before you can proceed to court. So you can see all those measures that are put in place with a view to cost management and, more importantly, cost reduction. In terms of any claims exceeding $400,000, the main rules, the main LMAA terms would apply. And in terms of the fee structure, there is the appointment fee to the arbitrator. Again, it's just like the intermediate claims. It's twofold. There's the appointment fee to the arbitrator, a flat fee of £350. And then there is what the nomenclature that they use is booking fees, which is essentially the arbitrator's fees, which the council of the LMAA has fixed at £1,250 per day for hearings up to 10 days duration. If the hearing exceeds 10 days, then the fees, the £1,250 per day is increased by 30% up to 15 days. And then if the hearings proceed up to 20 days, then the fees again are increased by 60%. Now, anything beyond 20 days, the additional sums in terms of fees to the arbitrator will then be agreed with the parties. And even in this kind of arbitrations as well, as much as possible, the preference is for a documentary hearing rather than an oral hearing.
Sorry, Dr. Olaoye.
Under the LMAA.
Dr. Olaoye, can you please try and
yes, please
wrap up because you've used up your time?
Yes, I'm wrapping up.
But, please
Sorry,
come and wrap up. We can take the other segment of your presentation perhaps later. If you could just wrap up on this one.
Okay, I was just going to jump.
We'll give you more time later.
Yeah.
Okay, so if you can do it in a few minutes.
Okay, sorry about that. So that's essentially the LMAA. Just quickly about the review work. Obviously, I can't talk too much in details about the work of the committee. It's still ongoing, but at least I can put some context behind the drivers of the proposed review. One, we should all recognize that we've really made giant strides in the past 3 decades in terms of engendering interest in arbitration. And we can also safely say that we're in the face of sort of consolidating and deepening arbitration practice in Nigeria. But the feedback that we get from the users of arbitration relates essentially to, we're sensing some whimpering about the issue of increased costs and also allegations of, irrational fee requests without any justifiable basis, and then applying rates that they say are not reflective of the environment that we operate in. And we then see that quite a lot of arbitrations are stalled on the basis of fees. So essentially the guiding principles of the committee is that we need a Nigeria-centric scale of fees that has a scientific and even, I dare say, actuarial basis. And that is what that is the work that we're doing. And in fact, we found out that it is actually possible to do that. A scale of fees that is reflective of Nigeria's GDP and other economic considerations. Thank you very much. Sorry I took too much time.
Thank you very much, Dr. Olawi. Sorry, I apologize. I didn't introduce Dr. Olawi before it started. You know, sometimes when you are in the presence, even virtually, of certain personalities, you tend to lose yourself. Dr. Olawi is a senior advocate of Nigeria, a fellow of the Chartered Institute. He is currently the president of the Lagos Chamber of Commerce International Arbitration Center. He is, of course, a maritime law practitioner and a lecturer. I believe he still lectures in the University of Lagos, and hence that is why he's speaking to you about the London Maritime Arbitrators Association. So thank you for that, Dr. Olawi. I'll move on, and we're doing very well for time. I thanked all the speakers so far for respecting that. I'll move on to the next speaker, Mr. Isaiah Bozimo. Isaiah is a partner in the law firm of Bodrick, Bozimo and Company. He's a fellow of the Chartered Institute of Arbitrators. He chairs the advisory board of the Lagos Court of Arbitration, Young Lawyers Forum. He's a representative of the representative of the ICC Young Lawyers Forum for Africa, Middle East, and Turkey. I could go on. Isaiah has vast experience in commercial dispute resolution. So Isaiah, over to you, please.
Ladislaw, thank you so very much, and I appreciate that very kind introduction. Just to update that I am the previous holder of the ICC's, previous representative of the ICC Young Arbitrators Forum, but I'm grateful for the introduction nevertheless. Good morning, good afternoon, wherever you may be. So just building on from the discussions that have been had so far, my perspective would be to give the experience from a practitioner's perspective as to the problems I see with arbitrators' fees. But before I do that, I really wanted to bring the audience into the conversation by conducting a very quick poll. And I would ask the CIR to please bring up the poll now. I just want to get an idea of what the flavor in the room is for your preferred framework. So the poll is this: if you have the choice, and let's assume there's a 1 billion naira contractual dispute, under which of these frameworks would you advise your client to arbitrate? So the choices are either ad hoc, using the CIR scale of fees, the rules of the Lagos Court of Arbitration, the rules of the Lagos Chamber of Commerce International Arbitration Center, the Lagos Regional Center rules, JICAM rules. JICAM is the Janada International Center for Arbitration and Mediation, and the ACC DRC, which is the Abuja Chamber of Commerce Dispute Resolution Center rules. So just take a moment to vote. I'm seeing some of the results coming in. So the choices so far are either ad hoc or using the LCA rules. And the majority is saying a panel of 3 arbitrators. We'll keep it for 10 more seconds as votes are coming in. So 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Thank you very much. Chinelo, you can end the poll for now. Thank you very much. We'll come back and revisit it, but just have a look at the results. The vast majority is saying ad hoc arbitration using the CIR scale, and they would submit that dispute to a panel of 3 arbitrators. Very interesting choices, and we'll come back to see what effect that might have in terms of the costs. But from a practitioner's perspective, I've seen difficulties relating to arbitrators' fees from 3 points of view, and I'll call them this. Either the parties are behaving badly, the tribunal is behaving badly, or the institution is behaving badly. And here's what I mean by this. In terms of parties behaving badly, I see that they fall into two broad categories. Either they're unwilling to pay, they're able to, but are unwilling to pay, because from a tactical perspective, they're trying to put pressure on a presumably weaker party to have the proceedings terminated. Or it could be, I've seen also that they take quite a trivial attitude into the proceedings. So they're able to pay, but because they're ill prepared, they're simply not following proceedings as properly as they should be, and nonchalantly conducting the proceedings and therefore missing deadlines to pay. I've also seen a situation where the parties are simply unable to pay. And in fact, I was discussing a case where a party that is unable to pay is now thinking about going to court to have the court revoke the arbitration agreement, because according to them, their inability to pay now means the arbitration agreement is incapable of being performed. So that's an interesting one to watch in terms of developing jurisprudence in Nigeria. But I've seen that if a party is unable to pay, it's usually down to two things. Number one, they're ill-informed. They're ill-informed as to what the costs will be going forward in this process. And number two, they're ill-prepared. Ill-prepared in the sense that you might have a legitimate claim for, let's say, 50 million naira. But for whatever reasons, they will add a claim to say, for example, general damages of 1 billion naira. And as Mrs. Adekoya said, on the basis that fees are assessed ad valorem, then you have automatically increased the value of the dispute and therefore the fees payable to the arbitrators. And I've also seen, in terms of tribunals behaving badly, what I see here is that, well, a tribunal usually will demand its fees upfront and unconditionally. So Mrs. Adekoya has pointed out the safeguards in the Lagos law, but under the ACA, those safeguards don't exist. So for instance, what would happen if the parties settle and you have already paid up front? Is a refund due to you? Or in a case I've encountered, if, for instance, the value of the claim drops, should there be a proportional decrease in the arbitrator's fees since it's assessed ad valorem? And in terms of institutions behaving badly, I've only seen one instance, and that is one where the institution had a policy of saying that we cannot issue refunds. And why that came up was that the hearing finished earlier than anticipated, and we therefore had paid for services that were unused, but because of the policy of the institution, could not obtain a refund. So why do all these things matter? It matters because cumulatively, it chips away at this image we're trying to portray of arbitration as an efficient, cost-effective way of resolving a dispute. What can be done about it? Well, Mrs. Adekoya has already given a statutory framework that's available in Lagos. But I think, as it concerns the parties anyway, that the more informed the party is going into a dispute, the more informed they can make a decision. So that is to say, am I prepared to arbitrate this dispute knowing how much it will cost me? Or should I take my dispute to an alternative forum? And that's pretty much the reason I conducted the poll. Now, I'd like to share my screen, if I may, for a minute. And I hope you can see it. Let me go back just a second. So the scenario is, let me reshare my screen, my apologies. So the scenario is this: we had a 1 billion naira dispute, and the majority of the audience said they would go to ad hoc arbitration using a panel of 3 arbitrators. Well, if you made that choice, you have automatically increased the costs of your proceedings. So using the CIRB scale in our virtual dispute, you're looking at fees of about 88 million naira. And admin costs, what I did for the admin costs, because it's unclear, the CIRB scale doesn't deal with administrative costs. So what I've done is to simply give an average of the other admin costs you see on your screen. And the average of that comes to about 3.4 million naira. If you had used the CI upscale with a sole arbitrator, you would have only paid 29 million naira. So just have a quick look at the difference between, depending on the framework you would have chosen. And let's now give a comparison of it in terms of the most affordable to the most expensive, and what that difference will be if you arbitrated before a sole arbitrator and before a panel of 3. So the most surprising one you will probably notice is the Abuja Chamber of Commerce Dispute Resolution Center. For a 1 billion naira dispute in a sole arbitrator, it will cost you 523,000 naira. That is the arbitrator's fees and the admin costs. And a panel of 3, it will cost 1.32 million. And I was so surprised by this, I had to reach out to say, well, what is the reason for this? And they tell me that, well, as it concerns domestic arbitration, they have an active policy that favors SMEs. So they're trying to encourage SMEs to adopt arbitration as a means of dispute resolution. And for that reason, have decreased their fees dramatically. And you go through the scale. So you see it goes all the way up to the LCA rules. And I know Dr. Olawoni is here, might say one or two things about that. But you can see how party choices will affect the costs you have to pay. Now, imagine you had this information beforehand, before you filed your notice for arbitration. Would it then change the way you would choose? Would it then change the framework? Would it then change the number of arbitrators? So let's relaunch the same poll. And I would ask you again to now make a selection. In a 1 billion naira dispute, with the information you now have, which framework would you use? And how many arbitrators would you submit to? So results are coming in. We'll give it 10 more seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Okay, so let's have a look at the results. Well, there was, in terms of the number of arbitrators, 62% now say they would submit to a sole arbitrator, because on average, you can see there's an increase in cost of 162% if you arbitrate before a sole arbitrator as compared with a tribunal of 3. In terms of the framework, the majority now says Abuja Chamber of Commerce Dispute Resolution Center. So I think that supports my theory that the more information you have before you go into the process, it will impact the framework you choose, and hopefully it would mean that the parties are less inclined to default in terms of payment of fees. So let me stop for here, and I'll look forward to any discussions that might come further down in the course of the webinar. So Leonard Silka, I'll hand over to you at this stage. Thank you very much.
Thank you very much, Isaiah. That's very, very interesting indeed. And I'm sure we'll have a lot of questions and comments arising from that. I erroneously described Dr. Lawi as the president of the Lagos Chamber of Commerce International Arbitration Center, but I have been corrected. Dr. Lawi is the president of the Lagos Court of Arbitration. Apologies. Like I said, we'll have plenty. The objective here is to have plenty of time to discuss the various presentations and the issues that have arisen. So we'll move on now. I'll call on Mr. Oba Nsugbe. Mr. Nsugbe is a leading practitioner in the UK and in Nigeria. Hence, that is why he's a QC over there and a senior advocate of Nigeria. Doubtless, he has vast local and international dispute resolution experience, and Mr. Nsugbe will draw on that experience for us now. Mr. Nsugbe, please, floor is yours.
Thank you very much, Mr. Belgore. And good morning to all of you, distinguished panelists and distinguished friends and guests in the audience. My remit is to speak from a perspective of a practitioner who does work, or significant amount of work, both Nigeria originating work and internationally originating work, principally the UK, and to give you some of the things that I see or experience working in those two jurisdictions, or those two areas, in the area of fees, and talking about one or two suggestions that I would have as to how we could address some of the issues that I see. Now, I'm amongst friends, so I will speak as frankly as I can about the issues and challenges that I see, and I do that with all sincerity and humility. First of all, I would say this, that the controversy and the concerns almost, I think, bordering upon challenge about fees is not just focused on Nigeria. It's not peculiar to Nigeria. It is something that I see internationally. Fees, costs of arbitration is something that the users of this particular dispute resolution service complain about and are worried about the world over. So those of you who are familiar with the empirical study that the Queen Mary University of London carries out in conjunction with White and Case will know that over the years they have an extremely detailed survey of practitioners, of academics, of users of arbitration, and come out with the results every year. And every year, high on the list about what is the worst characteristic of arbitration are costs. And the last survey saw that percentage at 69% were complaining about cost. The next worst scenario about arbitration, or worst characteristic, was lack of enforceability of arbitral directions. So you can tell that costs is high on the list of concern. And of course, that includes arbitrators' costs. Now, I'm going to just focus on what I see in both these jurisdictions. Of course, in Nigeria, most arbitrations are ad hoc. So by ad hoc, I mean the absence of an institution. And a well-run, well-structured ad hoc arbitration has a number of advantages. Of course, one is cost, because the institutional cost, let's not beat about the bush, the institutional cost can be quite high in institutional arbitrations. The second is flexibility. The parties can essentially choose their rules and they can move far quicker without an institution, and that should have an impact on costs. But of course, you do lose quite a bit without an institution, and that is the structure of a secretariat and the way in which they order an arbitration. But that is the general makeup of arbitration in Nigeria. The first problem that I see going between both jurisdictions is that, in general, I find in Nigeria that there is less respect for professional services. So what you find is that the users of arbitration, and indeed as colleagues ourselves, we do not value professional services as we should. And so what happens is, what you tend to see fairly early on is a wrangle about costs. So the tribunal will issue a direction that fees be paid, possibly in advance, and parties will start to question that, no doubt led by the clients. And I think for me, that reflects a general lack of valuing of professional services. And maybe that goes back historically to what's happened in our country, where we've seen a systematic degradation of academic, learned people. And we've seen, I think, publicly, many instances where lawyers and indeed judges are subject to ridicule. And it really is as simple as that. So often that you hear the public being told things about lawyers, and quite often it is deserved. So it builds up a perspective that you're dealing with a profession, or you're dealing with a judiciary which is not to be as valued as it should be. And so we are, in many ways, our own worst enemies there. And as I've said, quite often it is deserved. The second area that I see as a contradistinction between these jurisdictions is that there's a greater lack of trust between colleagues, between arbitrators, between parties. There just isn't the same level of trust as to what is happening, what we're being told, what is being ordered, all of these things. So that just leads to things being regularly questioned. And you'll find that in the middle of an arbitration, one party will simply say that there's not paying anymore. They're ceasing to pay because they don't like the way the case is going. And they are making allegations about various issues of conduct. And so that lack of trust, I think, is something that is a concern. The third area is something that has been touched on by Mr. Bozimo, and it's around the lack of information. So there should be a greater sensitivity to users of arbitration from the outset by arbitrators. So they need to be included in a very transparent and full way about what they're getting into. And sometimes you have to repeat back to make sure that it's understood. And so that means greater transparency about costs, what they comprise of, and exactly when they should be paid and why they should be paid at the various stages. There needs to be greater clarity about that, because if you don't do that at the outset, and I do see many instances, I'm afraid of that, if you don't do that at the outset, you're likely to run into trouble. The ad valorem system is obviously, it's all rule-based. The rules are there. We can see the rules, whether under the federal system or indeed under the legal state system, as Mrs. Adekoya was outlining very fully. The rules are there, but they do allow a fair amount of flexibility in the way in which arbitrators charge their fees. So what you tend to find is that one arbitrator may assess his or her value or costs at an hourly rate which is very, very high. That forces the fellow arbitrators to either step into line or issue fees that are significantly lower, or an hourly rate that's significantly lower. And that kind of irrational assessment or publication or agreement about fees is something that tends to lead to cracks, visible cracks in the way in which an arbitration is approached. The last area that I just want to touch upon is probably one that I would put under the heading of attitudinal. The attitude of arbitrators and indeed use of the system, I think is in Nigeria, I find is significantly more confrontational. And there's just a general lack of cooperation. And what tends to happen if a case is not going the way a party wishes it to go, or at the end of a case where a case has not gone the way a party wishes to go, and sometimes at the beginning of the case, we start off on a very confrontational basis where allegations are made, serious allegations are made with really no basis at all. And then the dispute very quickly descends into something which it should not be. And you find yourself having to do your best to stay out of that allegation and counter allegation. So what I would say is that as Dr. Aloyen says, we have made great strides in arbitration, certainly in introducing it as a very popular choice. But I have to say, we do have a long way to go. And that, for me, is around us increasing our honesty about the challenges and issues that are going on within our dispute resolution systems. One thing I would say, and I throw this out for debate before I end, is should we have a system where the users of the arbitration are permitted to assess the performance of an arbitrator in a structured way, answering questions that are uniform and speaking with examples, so that we start to really drill down in a serious manner into some of these challenges and problems. Thank you.
Thank you very much, Mr. Nsugbe. Last but not the least, I will now call on Chief Bayo Ujo, a man who certainly needs no introduction. Chief Ujo was the former Attorney General of the Federation, former president of the Nigerian Bar Association, a past chairman of the Chartered Institute of Arbitrators, just as Mrs. Adekoya is also a past chairman of the Chartered Institute of Arbitrators. Chief Ojo is a past chairman of the Nigerian Legal Aid Board and has been so many things and is still so many things. Again, all our time will be eaten up if we have to go through all that. So Chief Bayojo, the floor is yours, please, for 10 minutes. Thank you.
Thank you very much, Mr. Begore. And once again, good morning, everybody. And before I start, let me just specially recognize two participants who are with us this morning. And the first is Mrs. Hirat Balogun ON, who always makes time within her busy schedule to make sure she attends every event of the CIAB. She turned 79 last month, and I'm really happy to recognize her this morning. And the second person is Engineer Ebele Okeke, CFR, the former head of service, who is an engineer arbitrator. After she retired from the civil service, she now came to do her entry course, did the associate course, membership, and then fellowship. So I want to recognize these two special ladies, who find time to join us all the time. Let me say that if you recall when Mrs. Adekoya was starting her presentation, she said her job was to set the stage by giving the framework, legal framework, as regards to arbitrators' fees. And my own job is to wrap up the stage. And to illustrate this, I remember the story of the lady who got married. And when she got to the home of her in-laws, her husband was still living with the parents. Then she asked, "Who does the laundry here?" And the mother said, "I'm the one." She says, "Who does the gardening?" And the father of the husband said, "I'm the one." She says, "Who does some other chores?" And the husband said, "I'm the one." Well, she said, "Well, let everybody continue doing what they're doing. No problem." So all of them now looked up to her and said, "Look, so you, what will be your job in this house?" She said, "My work is to make your son happy." So my job really this morning is very simple, to wrap up what everybody has said. And let me say straight away that having listened to all the presentations, one symmetrical quote, which is noticeable, is that there are three methods of determining arbitrators' fees. The first one is the scale of fees, which is usually institutional. The second one is time-related. In other words, you clock the time you spend on each assignment and the cumulative time spent per hour will determine your fees based on how much you've agreed. For example, the LCIA used to be 300 pounds to 400 maximum. But the new rules that came up on the 1st of October 2020, last month, it's been jacked up to a maximum of 500 pounds per hour. The third method is what I call the lump sum scale of fees. And as Mr. Adeko stated earlier, this takes cognizance of the complexity of the case, the time that will be spent. Also, you look at any other circumstance, which would be involved in determining that particular set of fees. And to show the kind of problems usually experienced with regards to fees, I would cite one case, which is the case of Getma versus Guinea, which some of you will already be familiar with. Getma and Guinea is a case that came up under the OHADA arbitration rules, the CCJA. In that case, the amount in question was about $50 million. The CCJA had fixed a maximum fee under their rules of 60,000 euros for 3 eminent arbitrators. In other words, each of them were going to be entitled to 20,000 euros each. Now, after the preliminary meeting and a bit of work, the arbitrators felt that, look, this 60,000 euros is too small for the work we're going to be required to do. They then made a proposal to the parties that we'll be asking for a fee of 450,000 euros and that we want you to agree to this before we proceed. None of the parties responded, but later the claimant responded and agreed to it. But the claimant did, but the respondent never agreed to it. At least they never signified any agreement or disagreement. So the arbitrators proceeded with the hearing. They put in a cumulative time of 1,000 hours. 1,000 hours. So a lot of work was put into it. They prepared their award and then got back to the parties and said, look, hey guys, the award is ready, but guess what? If you don't pay this fee of 450,000 euros, we're not going to release the award. So the claimant proceeded to pay its own share, which is 225,000 euros, but the respondent never paid theirs. Anyway, to cut a long story short, this matter generated a lot of controversy, and eventually the award was annulled because the CCJ said, whatever happens, you must stick to the fees agreed in their rules. And since they are determined that 60,000 euros was the fees, so it was. Currently, the claimant is trying to enforce the award in the US, regardless of the annulment of CCJ in Africa. So I've given this illustration to show the kind of problems that are usually thrown up, by issue of arbitrators' fees. But my own personal experience is that most parties always prefer, when they see the scale, initially when parties go to arbitration, the claimant overtly wants to push everything in, damages of so much, this special, that, regardless of the fees. When the reality sinks in and they discover that the fees are going to be based on the amount of claim, then problems start. So, but my own experience is that most parties, having seen the calculation on the scale, which usually is huge based on the amount claim, would agree to lump sum fees if put to them. If, for example, now, let's say the scale of fees throws up a fee of $1 million, and you tell the parties as arbitrators, I say, look, hey guys, $1 million, but guess what? If you give us a lump sum of 600,000 for the 3 arbitrators, full and final. No matter how many hours you put in spite of the complexity of your case, whatever happened, no matter how long, not a dime will be charged after this. Most parties usually accede to this. So my experience shows that lump sum is the way to go most of the time. And let me conclude by saying that if the fees are too low, you don't get good arbitrators to arbitrate over your reference. Because an arbitrator will just say, look, what is the need for me? Why would I wait for a valuable time to go and sit down, lose other work I'll be getting elsewhere? And so you don't attract good arbitrators. But at the same time, when the fees are too high, you make arbitration less attractive. I've been in a reference where the fees were calculated on scale and we put it to the parties and they said they'll get back to us. And guess what happened? They went and confirmed. I said, look, instead of throwing all this money to arbitrators, why don't we settle this claim? And the next communication we got from them is that the arbitrators who have settled this matter will not be proceeding with arbitration again. So if you make it too high, you make arbitration less attractive and defeat the whole purpose of making it an efficient, prompt, and easy method of resolving disputes. So my take is strike a good balance, whatever scale you are using. Even if you use a scale of fees and it throws up the actual scale, give a discount to the parties and make them comfortable. If it's time related, agree on an amount which is acceptable to the two sides. If you say you charge $2,000 an hour, that's a bit on the high side. But if you say $1,000, maybe more reasonable. And then lump sum, you can always strike a balance between the case, the complexity, the time spent, and all that to arrive at an amount which will be acceptable to the two sides. Thank you very much.
Thank you very much, Chief Bayo. We already have a lot of questions and some very interesting comments. I will get to that in due course. But let me throw, just to set the ball rolling, some questions to the panelists. I want to start with Mrs. Adekoya. Then one of the distinctions you drew with between the Lagos Act and the Arbitration and Conciliation Act is that the Lagos Act specifically provides a lien for the arbitrator's fees, a right of a lien. Now, my question is, because the Lagos Act expressly say that an arbitrator shall have a lien, well, it doesn't use the word lien itself, but we know what we're talking about, and the ACA does not, does that mean you cannot exercise a right of lien under the ACA? Knowing, I ask this question because a lien is a common law right. And as lawyers, we know that only clear and express words of a statute can take away a common law right. So my question simply is there still a right of lien under the Arbitration and Conciliation Act?
My view is that it would be subject to debate. The idea is that there should be consensus between the parties and the arbitrator, and that the relationship between the arbitrator or arbitrators and the parties is contractual. And if you have issued your terms of fees and it has been accepted, and you have not specifically stated in your terms of fees that if your fees are not paid, I will exercise my common law right to a lien, it could be open to argument that having not expressly said so, you have waived that right. either way, the controversy would end up in the courts. If an arbitrator says under the ACA, my fees have not been paid, and therefore I will not release the award. The usual practice has been that where the arbitrator's fees have been agreed, the arbitrator then says, I will release my award on payment of the balance. And the party that is willing to collect the award tends to pay the fees. And therefore, I am not aware of any instance. Oh, I think there has been one instance where parties went to court to ask that the arbitrator release his award on the grounds that they had paid their share of the fees, the respondent had not paid their share, and they were not obliged to pay the respondent's share. I'm not aware how the matter ended up in court. So I think it's a matter that if a party is pressing, either the arbitrator is pressing that I must have my money or I will not release the award, you'll probably end up in court. And I'm not sure that's what you want to do.
Very well. Thank you very much. Or the old trick of the arbitrators is to notify the parties that I am about to conclude your award, but I should remind you that there's an outstanding fee. So the parties get the message that if we don't pay the fees, the arbitrator will probably not be able to conclude, or will probably not conclude the award. Thank you very much for that, Mrs. Adekoya. Dr. Olaoyin, I have a question for you, and I'd also like Mr. Nsugbe to speak to that. The problem we have sometimes here, quite a lot, is that parties are very enthusiastic and very willing to constitute an arbitral tribunal. But that enthusiasm drops off the moment the tribunal sets out its fees. Under the LMA, I know that you talked about an appointment fee. Does that address this kind of a problem in your experience? And I'll also, when you finish, we'll also like to hear from Mr. Nsugbe on that.
Thank you, Mr. Belgore. Yes, it does, but more importantly is the fact that the entire architecture of the fee structure in the LMAA is geared towards reduction of costs. So you would see that the appointment fee is a minimal amount, and even significantly in a reference that is well over $400,000, you can see how they've structured the arbitrator's fees more or less on a daily basis, so that it's not a function of that, oh, you have a claim for $5 million and then you start thinking ad valorem, which would then be the point where the parties, well, I guess it might not happen to British or European parties, but that's typically what we see in our environment, is that it is when you get to the issue of the arbitrator's fees, that's the only time that the parties are in alignment in terms of the cost of fees. But in the LMAA, everything is structured in such a way that there's really no argument. By the time you're entering into the reference, you already have a fair idea of what the entire cost implications would be, and even at the back end, what your potential liabilities for costs, legal costs, would also be, because everything is capped.
Thank you. Mr. Nsugbe?
Yeah, I'd only add, I think fundamentally the only thing that will increase that enthusiasm of parties is a discount from the arbitrators in reality. But under the LMAA, where you have an appointment fee and you have clearly and closely defined fees and schedules and payment times, I think that definitely helps. But it goes back to the issue of information and engaging the users in a clear, honest and transparent discussion right at the beginning about the arbitral journey which they're about to embark upon. And the more you do that, I think the more you manage expectations and the more you ensure that the enthusiasm level doesn't drop off.
Thank you very much. Okay. Mr. Bozimo, I have there's some questions directed specifically to you. But before I get into that, I just have a general question. Given that the lay party invariably is not even the one that made the choice of arbitration, he's certainly not the one that drafted the claim. He's certainly not the one that has chosen the rules of the institution upon which the fees are going to be assessed. Yet, he's the one that will bear the responsibility of paying the fee. Is there a role for counsel in this regard? Should counsel be advising their parties beforehand? Because the lay party is paying for decisions consciously or unconsciously taken by its counsel. So should there be a greater role for counsel? And if there is, what for you from Isioma Isiora? It says, would you suggest the tribunal may direct parties to scrutinize their claims further before deciding on his fees? E.g., could he explain the rationale for his charges to them? In other words, he's asking I think she's asking that the tribunal explain to the parties, do a greater job in explaining to the parties how and why they are charging whatever it is they are charging.
Leonard, so thank you very much. To the first question as to whether counsel should play a greater role in advising their clients, absolutely. And it starts at the stage of drafting the arbitration agreement. Because what you find typically is a lawyer in a relatively low value transaction will include a clause that says, for example, arbitration, all disputes refer to arbitration in Nigeria. And they think, well, I've referred it to arbitration. I'm encouraging the use of ADR processes. I've done a good job. What you've automatically done is subject a relatively low value dispute to an ad hoc tribunal of 3. Now, depending on whether or not a scale is used, that then brings up problems further down the line as to, for instance, its determination of fees and some of the uncertainties that come up as the case may be. Now, in terms of instituting a claim as well, that's where the role increases even more. So I find typically, particularly when I'm, especially when I'm a respondent, is that the genuine claim is usually a fraction of what is claimed in total. So the example I gave earlier was we were defending a claim of where we thought genuinely there could be a legitimate claim for about 50 million. But counsel will tend to add general damages in a contract dispute of 100 million, 500 million, 1 billion, which again automatically inflates the claim. Just to give an interesting story, there was a claim we pursued as claimants, but we were brought in later in the proceedings. We didn't initiate the claim. And our advice was we had to forego a significant portion of the claim simply because there was no basis for pursuing it. So I think counsel does have a duty in terms of advising their clients properly. To Mrs. Izuara's question, I actually answered it in the chat, but let me just reiterate the original point I meant. The point I meant, which I've just re-emphasized, was that a party should properly analyze its claim before submitting to arbitration. So you don't want to inflate the value of a claim because that will give rise to increased costs down the line. In terms of the arbitrator transparently communicating to the parties as to how the fees are charged, when fees are due, the consequences for failing to pay, I think that's always a good idea, as Mr. Ansube said. The more information available to the parties, the more informed their decisions will be, and presumably the less likely they are to be aggrieved by any decisions or to default as regards payments of the fees. So I'll stop there for now, and I hope I've answered the questions you put to me clearly.
Yes, thank you very much, Isaiah. Okay, before we go further, we have another poll ready now. Chinelu, can I ask you to put it up, please? Okay, please, can we have your answers to that? We'll take it in 10 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Okay, so we'll end the poll. Overwhelmingly, the question is, do you prefer a lump sum fee arrangement or scattered fees? By an overwhelming majority, 67% say they prefer a lump sum arrangements, and 33% say they prefer staggered fees. Obviously, Chief Bayo Ojo has been very influential. Thank you for that. Okay, I have a first question here. It's by an anonymous attendee. Please state your name. It always helps. It makes it a lot more interesting when we know you. And it says here, what determines the apportionment of fees in a terminated reference where none of the parties have paid before termination? Maybe I'll start with Chief Bayo Ojo. Chief?
I didn't get the question. What did you say was the question?
The question is, what determines the apportionment of fees in a terminated reference where none of the parties have paid before termination?
Well, I would just go 50-50. If it depends on the stage where it was terminated. If it's at the early stage, maybe before the preliminary meeting or after the preliminary meeting, I would apportion the fees or the cost 50-50 to each side. But if you've progressed into hearing, then you have to take other circumstances into consideration, like the behavior of the parties. Have they been diligent? Have they wasted time? And so on and so forth. So these are the considerations that will determine who gets a larger part of the to pay the larger part of the cost and who gets to pay a lesser sum. So at the end of the day, it depends on the stage, but averagely, I would say cost at that stage should be 50-50. Thank you.
Mrs. Adekoya, do you agree or disagree?
Well,
or how would you do it?
I have a different approach in that because the relationship between the arbitrators and the parties is contractual. Once the fees are agreed, I would put it in the procedural order that these are the fees, this is the stage, this is the initial deposit. If the proceedings are terminated at this point, this is the percentage that is due. If it is terminated at this stage, this is the percentage that is due. If it's terminated at this stage, this is the percentage that is due. That's the way that I have always worked. In which case there's clarity. If you terminate after parties have filed their pleadings on both sides, it's clear, just go and look at the procedural order. This is how much it's due for either side to pay. And parties would take that in equal shares.
Okay, thank you. Mr. Nsugbe, say this were happening in the UK, how would this typically be dealt with?
I think as Mrs. Adekoya says, there's usually a cancellation schedule. So ordinarily there will be very clear fee apportionment depending upon what stage the arbitration is reached, and that is issued. The arbitrators are at the commencement asked if they wish to adopt that cancellation schedule, and most do, because it's then very clear. I think, of course, the 50-50 approach will sometimes work, but where there are a number of issues to consider or imponderables that go to effectively having to assess in a more, I think in a closer way, I think it's better to go by a schedule of cancellation or putting it in the procedural order where you set out what's going to happen at different stages.
Okay, thank you. All right, before I go on to the next question, let me call on Mr. Isaiah Bozimo. He would like to make a point.
Thank you very much, Leonard. So just to add on to what Mr. Dekoya and Mr. Osugbe just said in terms of having a clearly defined schedule as to the proportion of fees payable depending on the time of termination. I've actually come across a case where that wasn't the case. In other words, there wasn't an agreed schedule prior to the termination. The tribunal or the sole arbitrator in that case terminated the proceedings and fixed his fees in what he called a partial final award. The parties actually challenged that before the High Court of the FCT. High Court of the FCT determined that at the stage of termination, it considered the fees too high and set aside the award, and the arbitrator got absolutely nothing. So I think it's absolutely crucial that the tribunal does set out the schedule so it's clearly defined at the beginning of the proceedings and it's agreed between the parties.
Thank you. Okay, I have well, it's more of a comment than a question, but I'll ask our panelists to speak to it. It's from Edward Luke, and he says, I had an arbitration where the claimant has not paid my fees, but the respondent has paid. The respondent refused to pay for the claimant's fees and has asked for the arbitration to be stayed pending payment. Let me take that again. I had an arbitration where the claimant has not paid my fees, but the respondent has paid. The respondent refused to pay for the claimant's fees and has asked for the arbitration to be stayed pending payment. It will be. Dr. Olawi, given this situation, if you were sitting as an arbitrator, what would be your reaction? How would you handle this? Claimant, I'll just take it again just to be clear. I had an arbitration where the claimant has not paid my fees, but the respondent has paid. The respondent refused to pay the claimant's fees and has asked, that is, the respondent has asked for the arbitration to be stayed pending payment.
And when Dr. Olawonyi is through, I would also like to contribute to personal experiences of the same scenario.
Okay, I didn't even realize that I'd been called upon to speak because I went off and I could barely hear. But from the little I gathered,
do you want me to repeat it?
You know, I think I picked up that the claimants hadn't paid, but the respondents had paid, and then they made an application to stay the proceedings.
The respondent that had paid is the one that made the application to stay the proceedings.
Yes, the respondent paid and then made an application to stay the proceedings.
Yes.
Yes, yes. I mean, this typically illustrates the issues around fees. The closest experience that I've had is that in situations like that, we've suspended proceedings for a period. I think a period of 6 weeks or something of that sort, and then again engage with the respondent or the defaulting party again, still no response, engaged with the compliant party who was still not willing to pay the fees, and ultimately the proceedings were terminated. So I would imagine that it depends on the appetite of the particular arbitrator, whether you want to leave that reference on your docket lying there with the potential that we have imagine in our own climb about issues of due process and disclosure and stuff like that. You might be stuck with that reference, and then suddenly, because you're stuck with that reference, you might lose the opportunity of dealing with another reference because of some kind of affiliation or relation with the parties.
If you were the arbitrator, what would you do?
Sorry, I missed you.
If you were the arbitrator in this situation, what would you do?
I will suspend the proceedings
Okay.
for a limited period.
Okay, thank you. Mrs. Adekoya, you wanted to speak to this.
Yes, I'd like to contribute to personal experience.
Yes, go ahead. Mrs. Adekoya has gone off temporarily on that. Chief Bayojo, can you share your experience on this?
Yeah, I won't hesitate to suspend the hearing. I mean, a claimant, first and foremost, is the person who has brought everybody together. And if the claimant is not willing to pay the fees, it means the claimant is not serious. And if a respondent has paid, I see no reason why I should ask a respondent to pay for the claimant, except if the respondent has a counterclaim. In which case, the respondent has an interest for the reference to proceed so that the respondent can prove that counterclaim and get an award in that regard. So I would suspend the reference pending when the claimant pays his own share of the fees.
Okay, very well. Since we've been conducting polls by participants, let me conduct a quick poll of the panelists. Given this situation, Dr. Laoyi will suspend. Chief Bayojo says he will suspend the proceedings. Mr. Nsugbe, what would you do?
Suspend on terms.
Suspend on terms. Mr. Bozimo, what would you do?
I align with Mr. Nsugbe, suspend on terms.
Okay, well, so we have 4 out of 5 will suspend on terms. The 5th person, we don't know her view yet. So we'll take it that that motion is carried. Okay, we'll move on to the next question. Just a quick one. We have a question from Mrs. Hira Balogun, and he says, is it possible for the Nigerian branch to educate members in limiting the number of arbitrators to 2? Because when fixing its fees, the cost is obviously more when there are more than 2. I was going to ask through this first to one of our past chairmen of the Chartered Institute, Chief Bayojo or Mrs. Adekoya, but I think it appears both of them might have dropped off for the moment.
No, I haven't dropped off. I'm here.
Oh, Chief. Okay. I'm not saying, okay, Chief.
Yes.
Mrs. Balogun is asking whether there's a role for the for the Nigerian branch to educate members in limiting the number of arbitrators to 2, because when fixing the fees, the cost is obviously higher when there are more than 2. Is that a doable thing? And what are the pitfalls of having 2 arbitrators?
The problem straight away is that a panel of 3 enables you to have a decision where there's a tie. In other words, majority carries the day. If 2 people are agreed, then that becomes the award, which is majority, and the person that disagrees is a minority award. But when you have 2 people and they both disagree, then you got a problem there. So I would not advocate for having a panel of 2 because it's going to be fraught with problems. Because
Okay.
if you either have a panel of 1 or 3, when you have 1, you cannot disagree with yourself. So you can only give what the decision you've arrived at is. But with two, there can be disagreement, and you'll have a hung tribunal, which becomes problematic. So it's better to have that extra one person to make a panel of three, and then pay the little extra that is necessary to the increase for a panel of three than to have two.
Okay, thank you, Chief. Now, I have a question from Mr. Ayodele Akitunde, SN. He says, parties now regularly ask for discounts on arbitrators' fees. Many panels are open to giving discounts. What range of discounts should the tribunal consider giving the parties? Chief Ujo, if I may start with you, because you were the one who first raised this issue of giving a discount in this webinar. What range of discount might you be willing to give?
Well, I wouldn't say a particular percentage across board. It will depend on the nature of the dispute, the complexity of it, the time I think I'll spend on that particular dispute, and all the various circumstances surrounding it. So it's difficult to have a one-heart-fits-all discount and say, look, I'll probably give a discount of 10% or 20%. I will not be able to be in a position to say that. It will depend on each circumstance as it is presented. But definitely I'm for discounts because economies all over the world are down. And so the purchasing power of parties and their clients will also be affected. So I'm an advocate for discounts. Thank you.
Okay, thank you for that. But the follow-on question, which is mine, is that
Yes.
knowing that you will give a discount,
Yes.
would you then have charged your fees in the expectation of giving a discount?
No. I wouldn't do that. Usually, like in scale of fees, when the fees have been worked out based on the scale, you know what the actual fee should be. So you cannot charge that in advance because the scale is fixed. And then you can give a discount based on what has been calculated on the fees. In the case of time related, you can always negotiate on how much you are charging per hour with the parties. If you propose like $1,500 per hour and they feel it's a bit on the high side, you can at least agree on maybe $1,000 per hour. So that's also a discount in a way. With the lump sum, that is based on negotiation. So whatever discount is given is actually embedded in the negotiation itself. I mean, if you propose a fee of, let's say, $1 million, and the parties say, we'll offer you $600,000, and at the end of the day, you arrive at $750,000, so the discount is already embedded there.
Okay, thank you, Chief. Mr. Nsugbe, how is it done in the UK regarding a discount? I ask this because, sorry, just a minute. I ask this because drawing from my own experience, I remember a long time ago, I was in an arbitration with I was a member of a panel, and one of our co-arbitrators, a UK practitioner, when he stated his fees, this is to us, the members of the tribunal, because the idea was we were trying to set the fees. And without anybody asking, he says, well, these are my rates, but I'm perfectly prepared to negotiate it. So he was offering it up front without anybody even asking for it. Is this how it works, or how does it work?
No, I would say that's an exception. It's good to see Mrs. Adekoya back, because I think she was about to give two examples on that naughty problem that came from
yes, I'll get back to that.
Edward Luke. But can I just say two things about this? The lump sum route, which Chief has outlined, is a flexible route and probably an attractive one, but it does have its drawbacks. Because if you go down the lump sum route, you do find yourself being sucked into a bartering type scenario with the parties quite often, and that isn't always befitting of an experienced arbitrator who has a value. I'm just saying I'm just signaling, I'm not saying it's wrong. It is a commonly used approach, and it has a number of real advantages, but I just want to point out the drawbacks. But to your question about discounts, I would say that discounts certainly over here are quite rare, because there is a greater focus on realistic fees explained in a very clear way upfront, setting out exactly when those are to be charged, why they're to be charged, and how much they are. So once those are set out to the parties, I haven't been in many cases where arbitrators have said, okay, let's discount. But it's more common in Nigeria, undoubtedly, and I have been in many instances where there's been a discussion around discounts. I certainly appreciate the times that we're in. These are challenging times where there is certainly an economic downturn, as Chief Bayojo said, where there does need to be a greater degree of flexibility. But it does need to be balanced, I think, against a situation where arbitrators, after all, we are an educated profession who have a value, get dragged into a kind of market type bartering.
Thank you, Mr. Nsugbe. Okay, we have Mrs. Adekoya back, and she was just about to share an experience with us. Can I ask you to please give it to us briefly? I see we have less than 20 minutes left for this webinar, and we still have a few questions we would like to go through. So, Mrs. Adekoya, please share the experience you were going to share with us.
Thank you very much. I'd like to just do a short comment on the question of discount. If I'm a sole arbitrator, I would either give you a lump sum or I would give you an hourly rate, and I'll provide a timesheet. If where I have been the chairman of a panel, I have given discounts if it's been asked for, because my time value as a senior advocate would probably be higher than the time value of my colleagues who may not be either so senior as senior advocates or may not be senior advocates. So there's an opportunity for me to discount my rate to ensure that we proceed. So that's my answer. In respect of the question that Edward Luke raised, in the ancestral arbitration, respondent paid, claimant didn't pay. Respondent eventually asked us to terminate the arbitration and award the costs. And that was exactly what we did. It was organized under the auspices, it was ancestral, but PCA administered. And so we issued a final award on costs. We dismissed the claims without prejudice. So the claimant could come back. Respondent had a counterclaim. The claimant didn't pay, and the respondent eventually distinguished the costs of the counterclaim and the costs of the claim. And we will proceed, we are prepared to proceed with the counterclaim if the claimant is not prepared to pay its share of the claim. We've just had the hearing, and we have said that if the claimant does not pay on its claim by a particular date, we will close the hearing, in which case the claim will be dismissed without prejudice, and we'll give an award only in respect of the counterclaim. So those are my two experiences.
Thank you. Now, I have a question from Hamid Abdul Karim, and he says, in cases where there will be 3 arbitrators, one sometimes sees party-appointed arbitrators seeking to agree their fees and other terms, such as cancellation charges, with their appointing party before accepting the appointment. Do the panelists think this approach is acceptable? Let me start with you, Mr. Nsugbe. In cases where there will be, let me take it again just for, in cases where there will be 3 arbitrators, one sometimes sees party appointed arbitrators seeking to agree their fees and other terms such as cancellation charges with their appointing party before accepting the appointment. Do the panelists think this approach is acceptable? And after that, I would like Mr. Bozimo to speak to this also from a practitioner's point of view. So, Mr.
Okay. Thank you, Mr. Belgore. I'll answer that shortly in a moment. But before I do, I just wanted to make a point that I think was raised by Mrs. Balogun around the two arbitrator system. I'm just looking to Dr. Olawi that under the LMAA, there is provision, in fact, for 2 arbitrators to proceed with the case and bring in a 3rd arbitrator effectively at any point before the final award, which makes it a lot cheaper. So if the 2 arbitrators are in consensus, that is a system which is quite regularly used under the LMA. In fact, I'm in one now where there's only 2 of us, and we're going to the end. But let me go back to the question that you asked. I think that is fraught with danger, where party-appointed arbitrators in contact with their parties that appointed them are agreeing fees ahead of a tripartite agreement and a discussion which involves all parties is, I think, fraught with danger. Because if one party appointed arbitrator agrees a fee that is significantly more than the other party appointed arbitrator, you there have the makings of dispute right at the beginning. So I wouldn't countenance that as an advisable way to go. Okay,
thank you. Mr. Bozimo, I suppose you won't disagree much with that.
No, absolutely not. It's certainly it's not something we would pursue. It's too fraught with danger, and my approach is to try and limit the scope for disagreement down the line. So it's not an avenue I would pursue.
Okay, thank you very much.
Let me just add that sometimes when a party is trying to appoint an arbitrator, even if it's going to be 3 party appointed panel, they sometimes insist you give them an idea of what your charges will be. And if you do that, by the time the full panel is constituted, whatever you've agreed before fizzles out, and you're back to what the panel will be agreeing to now.
Okay, thank you, Chief. Now, I have a question from Henry Omosiego. He says, I hope I pronounced that correctly. Please, when is a fee for services earned? Is it justifiable for an arbitrator to demand for fees to be paid before given a ruling, assume an award on the matter in dispute? Dr. Olawi, can we start with you?
You have to repeat that because I just joined back. Yes, I dropped off, yes?
Is that, the question is, sorry, I'm just trying to get it. Well, I'm not picking up at the moment, but essentially he's saying that, is it justifiable for an arbitrator to charge fees when he hasn't delivered an award?
Of course, as had been said earlier, at the preliminary meeting, you would typically set out the various milestones by which fees are payable. And the fact that an award has not been published doesn't mean that the arbitrator has not done any work to justify any fees that have been earned once the milestone is met. I think the issues would typically arise, and I saw one of the questions, which was what happens in a situation where immediately or shortly after the preliminary meeting, the reference is either terminated or something like that. Then you can have issues around whether or not any fees have been earned in that situation. But so it would depend on the particular circumstances in terms of what extent the parties had reached before, for some reason, the reference stalled. If, for example, pleadings had already been exchanged, arbitrators had spent some time studying the documents and stuff like that, then obviously, if the proceedings terminate afterwards, certain fees will have been earned without an award having been published at all. So it just depends on the circumstances, which again explains the points that had been made by all the panelists, that it is extremely expedient that you set out the milestones for earning fees in your very, very first contact with the parties.
Okay, thank you. Of course, arbitrators are there to deliver an award ultimately, but in the process of delivering an award, there's a lot of work that would have gone on, so they are entitled to be paid. I have another question here. It's from an anonymous attendee. It says, is it appropriate for a presiding arbitrator to fix the fees of an arbitration without consultation with the co-arbitrators? I throw this open generally to all the panelists, and now whoever wants to take it first, please go ahead.
I'll start first. I think it is.
No, it's not appropriate.
It's not appropriate.
Okay. Yeah. It's wrong.
I suppose they're all unanimous on that.
It's a bit high-handed.
Okay, thank you.
I've actually had an experience where the arbitral panel couldn't, it was a PCA dispute, the arbitral panel couldn't agree on the rate of fees, and one of the arbitrators then resigned.
Okay, thank you.
Before we went out to the parties at all.
Okay, there's another question here. This one is from Oluwasami Oloruntimeyin. Would advising the parties to reconsider the relief sought not be deemed to be descending in the arena and adjudicating ahead of the hearings? Shouldn't this be essentially role of counsel? Is this not a fine line that can be easily crossed? Panelists.
Lennis, look, I think that may be directed at a point I made earlier regarding evaluating your claim before pursuing arbitration. So the point I made was not for the tribunal to
Isaiah, please speak up. Please speak up.
Oh, my apologies. Can you hear me now?
Yes.
My apologies. So the point I was making was not for the tribunal to conduct the assessment as to whether the claim was appropriate or not. It's for counsel before submitting the claim to conduct that assessment. So it's not a function of the tribunal. My point was it's a function of the parties and counsel.
Okay. Yes, I take it that was the point you were making. But the question is, would advising the parties to reconsider the relief sought not be deemed to be descending into the arena and adjudicating ahead of the hearings? Say you're an arbitrator and you present your fees, and you are in a referee. You present your fees to the party, and the fees are high because it contains some obviously exaggerated claims. The question is, do you point that out to the parties, or do you just say nothing?
I think you have to approach it with tact. So the point is not to advise the parties as to whether their claim is inflated or not, but to emphasize the point that the fees will be based on the claims that are presented. So hopefully the parties will pick up on this and make any necessary adjustments that they would. But it's not for the tribunal, I think, to advise the parties on whether a claim has been exaggerated or not.
Okay, thank you. We have just 5 minutes left for this webinar. So I would like to take two more. I think we can only take two more questions. This one is from Akinola Akinyeju. It says, what happens where one of the arbitrators dies after earning his fees in an ongoing arbitration? Will the parties be compelled to pay another arbitrator appointed for the same service. Again, I throw this open to the panelists, whoever wants to have a go at it.
I would start on that. If it's a panel of 3, the presiding arbitrator should just apportion the amount of the fees that had been earned by the arbitrator who had died and pay that to the estate of the deceased arbitrator and pay the balance to the new, that's what I would do, and pay the balance to the new arbitrator. There would be no requirement for a double payment.
Okay, thank you.
No,
Chief,
I don't think
Chief
the
Bayo,
question
would
is,
you do it differently?
no, I got the question wrong. I thought the question was if an arbitrator had earned a fee, had been paid and dies, would he make a refund? Is that the question?
No. Let me ask the question again. What happens where one of the arbitrators dies after earning his fees in an ongoing arbitration? Will the parties, after being paid, will the parties be asked to pay the new arbitrator?
Well, it depends.
For the same service.
It depends on the parties. If the parties are magnanimous because of death, they can waive the fact that the party hasn't paid, and I mean, one of the arbitrators hasn't paid and is dead and pay new fees. But I have a case in point where the parties actually sued the estate of the dead arbitrator. The case is currently in court.
I think it's there's no decision on it,
Yeah, no decision on it yet. So, but like I said, it depends on the parties, how magnanimous it. But going by Mr. Adekoya's way, if that happens, the other 2 arbitrators can contribute out of their own fees, which they've earned, to be paid to the new arbitrator. That's the solution to it. Well, I mean, assuming that each arbitrator has been paid 10,000 naira, one arbitrator has died and a new one appointed. The other 2 can decide to contribute out of their own fees and let 3 of them now have the same share. You know, that's another way of which Mr.
Well, when you say they can decide to contribute their own share of the fees, are you saying this is out of the goodness of their heart, or are they obliged to do so? I think that's really what to know. Are they obliged to do so, or is it at their discretion?
They're not obliged to, because the first point I made
had earned his fees, then the new arbitrator just continues and earns his fees. If the deceased arbitrator had been paid up front and had not earned his fees, or had not earned all of it, which is the case that is ongoing in court.
In court, yes.
Then this is the easiest way to go for and collect the balance of the arbitrator's fees and have some discussion with the estate of the deceased arbitrator and the new arbitrator. That's the way I would go about it.
Thank you very much. I'm sure we can go on and on this subject, but we've really run out of time. It's left to me to just say, I think sometime in 2004, I did give a talk on arbitrators' fees at a members forum, and some of the issues we've discussed today, I talked about in that. I will make the paper available to the secretariat of the institute. So if you anybody who's interested, if you get in touch with them, I'm sure you can get a copy of that. All that is left for me is to thank our eminent panelists, Mr. Isaiah Bozimo, Mr. Oban Sube, Mrs. Funke Adekoya, Dr. Wale Olawoye, and last but not the least, Chief Bayojo. We thank the Chartered Institute for providing this opportunity for this discussion. And I personally would like to thank the General Manager of the Chartered Institute, Mrs. Chinelu Obala, for providing the background support, and to thank my own assistant, who's not visible but is here directing me and guiding me, Mr. Olayinka Ajose Adiogun. I hope we've all enjoyed this webinar. Thank you very much. And